Hi, I'm Malcolm Burrows, Principal and Chief Sanitary Officer of Dundas Lawyers. Dundas Lawyers is an award-winning corporate technology and intellectual property law firm that is unique in that we do both front-end advisory work and we also litigate in our areas of practice. In this short video, I'll discuss the admissibility of evidence and usefulness of evidence from the Wayback Machine. So the first question that arises, of course, is what is the Wayback Machine? It's an online service that allows users to access archived versions of websites, although it is cut down in terms of the technology and what you can see. Since its launch in the late 90s, it's catalogued over 400 billion pages of websites for users to view what was seen in the past and what appeared on a certain website on a certain date. To surf on an archived version of a website in the Wayback Machine, users simply need to type in the URL and select a date range. The Wayback Machine can be useful in litigious matters requiring historical evidence of what was on a particular website on a particular day. This might include, for example, the website's content history and the number of pages at a particular point in time, the date that a website was first seen on the internet, of course, and whether the website was continually in use after it was first made live. One case that dealt with evidence on the Wayback Machine is the case of King LLC and Brosnan Golf Proprietary Limited in 2014 in the Federal Court. That case dealt with an application under Section 31 of the Trademarks Act. The question was whether registration of a trademark could be opposed on the ground the applicant was not the owner. So in an attempt to prove that the website was in use, the applicant provided affidavit evidence on searches that she'd completed of the Wayback Machine. She also identified web pages from King Par's website records that were contained on the website on the Wayback Machine. In considering this evidence, Justice Applegarth said the material showed a long history of use of the mark continuously from 1998. However, the court questioned the accuracy of the dates on the Wayback Machine pages, and because nothing turned on it, they didn't have to rule on it. So are reports from the Wayback Machine admissible as evidence? The recent federal court case of Dyno Nobel Inc. and Orica Explosives Technology, number 2, in 1919, considered the various grounds for the admissibility of evidence from the Wayback Machine. In that case, the substantive proceedings were commenced by Orica, seeking revocation of a patent. Dyno Nobel subsequently cross-claimed for infringement of its patent. The court considered whether the reports gathered from the Wayback Machine were business records pursuant to Section 69 of the Evidence Act. So, once Orica further submitted that the evidence contained in an affidavit was not admissible as business records with the meaning of Section 69 of the Evidence Act, because they were not documents of either of the parties to the proceedings. That doesn't seem particularly controversial. It was held that the patent's priority date was constituted of the business output itself, specifically the process of storing and collecting records from the internet and making them accessed publicly. Accordingly, these would not fall in the concept of internal business records. The court also considered Section 190 exception to the hearsay rule. Under exceptional circumstances, the court may waive the hearsay rule in accordance with Section 190 of the Evidence Act, where the evidence is not in dispute or its application would result in unnecessary expense or delay. The court may also consider the significance of the evidence of the proceeding and its probative value. Accordingly, Justice Burley allowed the materials from the Wayback Machine to be admitted as evidence, but only to prove the existence of certain pages on certain dates. Evidence of the truth or otherwise of the content of the pages adduced from the Wayback Machine was not admissible. So, the takeaways from this is that evidence from the Wayback Machine has been held to be hearsay. The business records exception to the hearsay rule does not apply. That said, reports from the Wayback Machine itself may be admissible if there are other evidence that tends to support its accuracy. Litigants seeking to rely on reports from the Wayback Machine should ensure that this material is not relied on in isolation, and they are not seeking to rely on the content of the pages themselves without further information and further evidence. So if you're looking for a savvy law firm to assist with the adducing of evidence that may be contained on pages from the Wayback machine, please don't hesitate to call me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.